Alright, buckle up, this one starts light, but don't be fooled. What we're about to watch is a perfect storm of courtroom confusion, a self-represented defendant, misunderstood procedure, and a judge trying to keep it all from going completely off the rails. Question for you, have you ever walked into something thinking, I got this, and then realized you absolutely did not?
The last case is City of Saline versus Lisa Dehart.
Yes, Jack, City of Saline.
Okay, now can you hear me?
Can you state your name?
My name is Lisa Dehart.
Okay, and are we proceeding to a formal hearing?
I believe so, Your Honor.
Okay,
Yes.
Your Honor, I believe this is Ms. DeHart's appeal of a finding at the informal hearing, and the city would call Office of
just give me
Belknap.
1 second. My notebook. Any opening statements from either party? Mr. Ojak.
No opening statement.
Ms. Dehart, is there anything you'd like to say for an opening statement?
Here's that paper.
I am asking that you, this is an appeal on a case. I just want to make sure you have a photo with you.
Ma'am, that's not the appropriate way to enter evidence.
I'm sorry.
So
Okay.
you did enter it.
Okay. You should have a copy of it is what I'm saying. I'm sorry. So what I'm trying
I don't
to...
have any, ma'am, I don't have anything.
Oh,
This is fantastic all the way through. Okay, so she lost her traffic court with the magistrate because, well, she was guilty of sin. And so she appeals it and apparently goes to this judge. This judge is excellent. And by the way, I might add, she's a cutie. But she is so funny. She handles this really well in terms of law the whole time. But watching her, she never loses it, but she is restraining herself the entire hearing. It's so comical.
Okay.
at the time of the appeal.
Okay. At the time that I made the appeal, I made this photo, and I have others available, and they received it at the court, and they said that it would be with the paperwork. So
And here's our first major legal misstep. Evidence doesn't just exist, it has to be formally submitted according to procedural rules. This is called entering evidence into the record. No submission, no consideration. It might feel like a technicality, but in court, procedure's everything. Miss this step, and your strongest proof becomes legally invisible.
I can either show it to you now, but what I'm trying to let you know.
No, prior to an appeal, you have to make it part of the record and submit it to the court ahead of time and submit it to opposing counsel. None of this has happened because she doesn't know the procedure, the rules of evidence. That's not shocking, but it's just sad to watch her, go through that. The judge is not having this. The photo's not in evidence. The end.
Is that I'm asking for an appeal on the magistrate's ruling.
The appeal.
I'm asking for an appeal. This is the appeal. Yes, you filed for an appeal, and we are currently in the middle of conducting that hearing right now. You're not asking for some future event. Your life is now.
Right. So I would like you to, I don't know the right word, that I received a
No, you don't.
lane violation. I'm sorry. I wrote it down so I can try it. Is it okay that I read some of this? Okay.
Totally fine, ma'am. I just want to make sure to understand you have appealed this case. This is your appeal right now. So we're having another formal hearing right now in front of me. Okay. So just like your other hearing.
To this moment, right here, classic courtroom reality check. She thinks she's requesting an appeal, but she's already in it. This is what lawyers call a de novo hearing, a complete do-over, not a review of the past. Translation, there's no rewind button. No, let me fix my argument later. This is late.
Okay. So that I received an impeding traffic ticket for improper lane use for driving straight in a right turn only at Michigan and Riverside. November of 2021. I tried to explain to the magistrate at the last Zoom that the lane was not marked right turn only, and she continued to say that it was. I did not want to continue to argue with the magistrate, And when we left the
I like how she characterizes that. I didn't want to continue to argue with the magistrate. No, it was over. You lost. You didn't have the option to continue to argue with the magistrate.
court, we went back to the intersection, took a picture, and turned this in to the court.
Ma'am, can you
Yeah, it's always a good time to gather evidence after you lost the hearing. That's the perfect time to start.
please put that down?
Yes.
Oh, man.
So I submitted evidence to prove that the lane is not marked as a right turn only lane, which is
Except you didn't submit any evidence.
what I got my ticket for. And I paid the fine, and they said that I could ask for an appeal, and that I would get the sorry, I have a little coach husband next to me, so I
know, and we can hear him. If he could please not, we can pick him.
I very much have to apologize for that, because he does that. I'm really sorry for that. You deserve more respect than that, so I apologize. So the appeal is just that. I wanted to appeal the judgment, and that I submitted evidence that clearly shows that this is not a right turn.
Okay, she's aware of the postural history. She just told it to you. You're spitting it back wrong, and you still haven't submitted evidence.
Only, and I don't know what, I won't pick up the paper again because she told me not to, but it is definitely it's marked clearly that the way I drove was fine. I guess is the best way for me to say that to you. I don't know if it's at Riverside and US 12.
Thank you. Mr. Ojak, do you have any witnesses for the people?
Call Officer Belknap.
Okay. Officer Belknap, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, ma'am.
Lower your hand, state and spell your name for the record, please.
I'm Officer John Belknap, JOHN for the city of Saline.
And you're employed as a police officer by the city. Can you briefly tell us your history as a police officer?
I've been with the city of Saline for about 8 years. Before that, I was a sergeant at Pittsfield Township Police. I retired from there in 2013 and started with the city of Saline in 2014.
And you were on duty on November 10th of 2021?
I was.
Approximately 7:48 in the morning?
I was.
And you were in the area, at least it's the area of Michigan Ave and Whitlock?
I was, sir.
And that's in the city of Saline, Washington County, state of Michigan?
It is.
Were you there randomly, or were you there for a certain purpose?
I was there for a certain purpose, sir.
And what was that purpose? Why were you there?
We had received, we being dispatch at Saline Police, had received 2 calls from motorists west of the city on Michigan Avenue complaining about a green Mercury Villager, Ford Windstar van that was eastbound on Michigan coming towards the city. The complaints were that it was passing in no passing zones, and that people were having to go off the road to avoid or to give room for oncoming traffic to.
Oh, I missed this the first time through. She actually got called in by other drivers, and it's a green minivan, which is just perfect.
To pass. And so I was sitting at Whitlock specifically looking for that. I do have an emailed statement from one of the witnesses, but I'm not sure that's really appropriate or admissible, since these are all issues that happened outside of the city.
So I was just looking for the reason you were there. And did you see that vehicle at that location at some point after you waited?
I did.
And can you tell us what you observed?
I can. I had pulled into the mobile station and drove around behind it. So I was on the east side of the mobile station, on the easternmost drive of the mobile station, which is pretty much near Whitlock Drive. And as I got into position to watch, I saw the green van that I ended up stopping was in the right-hand lane coming down the hill from Austin Road. Austin is also Riverview that goes to the south, Austin Road. The vehicle was passing other vehicles that were in the main travel lane, and the vehicle in question merged over fully into the lane as it was passing the first drive of the mobile station. I can give a description. I actually went and measured it out on Google Maps, and I can describe the signage of the road. After you pass Austin Road, about 165 feet later, there is a sign. It's a yellow diamond sign that clearly states that right lane ends. Also at that yellow diamond sign that states right lane ends, the hashed white line that separates two eastbound lanes of traffic ends. About 200 feet past that sign and the end of the hashed white line, there is another yellow diamond sign, and that yellow diamond sign is a graphic that lists a straight line on the left-hand side, and on the right-hand side it has a line that curves over to the left that once again indicates that the lane on the right-hand side of the road is ending and should merge over. After that sign, approximately 365 feet, you come to River Oaks Drive. River Oaks Drive is the entrance to the trailer, I'm sorry, not the trailer park, is the entrance to the apartment complex there. After the entrance to the apartment complex, which is River Oaks Drive, the lane starts to noticeably narrow. Where Mrs. DeHart ended up completing the merge over was approximately 290 feet past River Oaks Drive. Additionally, as she was merging over, not only did she do so with apparently not using her signal to merge over, the car and
I use my signal all the time.
Ma'am, you can't make any comments right now.
Oh, I'm very sorry. I forgot.
No problem. Anyways, as she was merging over, she was almost forcing herself between a line of traffic, and the vehicle in front of which she was merging had to slow down. I was able to see that its headlights dipped briefly as she was merging over in front of it. I ended up stopping her quite a bit east of downtown. Took me a little while because traffic's difficult at that time. I stopped her for I guess the most appropriate charge would be the improper passing or the failing to yield as she merged over in front of the car that had to slow down to let her in. And I issued her the ticket for impeding traffic. The ticket was not issued for going straight through at a right turn only at River. That might have been a misunderstanding with the magistrate, but that wasn't what the traffic stop was for, and that wasn't what the ticket was for. The ticket was for continuing in the right turn lane past River Oaks, where the lane had ended, and merging over in other traffic that had to slow down to allow her in.
At the point she entered, how wide was that right-hand lane at that point? Was it a full lane?
No, not at all. The lane starts narrowing significantly right at River Oaks, and she was finishing her merge about 290 feet past River Oaks. There were no white lines delineating two lanes traveling east. Additionally, where she completed the merge, instead of having two lane widths, I'd estimate there was about maybe 1 1/4 to third lane widths where she completed her merging over.
And you said you were at the mobile station. When she completed her merge, where was she in relation to the mobile station?
There are two driveways to the mobile station, and the first one she came to would have been the west drive to the mobile station. She was completing the merge at the west drive of the mobile station as she was passing the driveway to mobile.
Nothing further, Your Honor.
Ms. DeHart, do you have any questions for the officer?
Oh, here's where it gets delicious. This cross-examination is fantastic. It's actually worse than Amber Heard's attorney's cross-examination on these witnesses.
Yes. My question for the officer is that
All right, this is where things should get strategic. Cross-examination is the moment to challenge the witness, poke holes in their story, and control the narrative. But here's the catch: it only works if you ask actual questions, not give speeches. Watch closely, this is about to go sideways fast.
I'm trying to do this correctly, so if I do anything that's wrong, I appreciate when you correct me.
Everything you do is wrong.
So my question for the officer is that I changed my lanes with my, well, that's not for the officer, but I always use my turn indicators when I change my lanes. I guess I'm a little confused about the fact that
Look at the judges.
that is not
this is
at
questions
all,
at this point.
that was,
Ms. DeHart, can you ask questions? Your opportunity to testify. It's your opportunity to ask the officer questions about what he had just testified to.
okay, that this testimony that he is saying now is not what was testified in the previous magistrate court. He's changed his testimony from then.
It's not your turn to testify. It's your turn to ask him questions, not me.
Yeah, I'm asking. Okay, I'm sorry.
She needs some work on perfecting an impeachment here.
I'm asking him why he's changed his testimony. All of this information is not part of what was at the magistrate. So why did he change this? I do want to know, did he go back and check the lane usage, which is what I was told, that it was improper lane usage because the court magistrate said that the lane was properly
I'm going to object again.
marked.
The officer hasn't had a single question to be able to
Okay,
answer.
I did. Okay, so why did he change his testimony and say that it's not for improper lane use when that's what we did in the previous magistrate? Why is this testimony different than what we talked about in the previous? I was told specifically by the magistrate.
Ma'am, one question at a time. Let him answer.
Well, let's start with the problems with this. It assumes facts not in evidence. It's irrelevant. It calls for hearsay as a response and a legal conclusion. But other than that, it's fantastic. Let's carry on.
Okay.
Okay, my testimony in this case is a little more detailed than it would have been in the informal hearing. And the reason for that is, and I actually took measurements on Google Earth and samajhna.org mapping system. That's how I had the exact measurements of the signage, where the road markings were, etc. As far as what you were stopped for, you were stopped for, it could be improper lane use. It could be the fail to yield for merging over. There were a number of violations that would have been appropriate. And I ended up issuing the impeding because that's a 0-point violation.
But I asked you, why did you change your testimony? Because the, what is it called, an informal hearing. So you didn't really answer my question. My question is, why did it change from the lane usage, which the magistrate previously made it very, very clear that this was specifically regarding using the right lane to go through, and that the right lane, she repeatedly said that the right lane is a right turn only lane, clearly marked, which it is.
Okay, so here she is testifying again. And the prosecutor, by the way, is really sharp and sees all of these objections. I would do the same thing. You let them hang themselves for a while, and then you just hit them with one big objection, and the judge says, knock it off with everything. It's almost better to let it go on, and he handles it perfectly.
Is not, and I have proven that. So
Your Honor, I'm going to object.
want to know
What
why.
magistrate said, I didn't say.
Ms. DeHart, hold on, there's an objection. Mr. Ochoa.
Objection is crucial. The prosecutor is basically saying, forget the first hearing. It doesn't matter. And the judge agrees. Why? Because this is a fresh trial, not a review. No deference, no second guessing, just new evidence, new testimony, clean slate. If you didn't bring it properly this time, it's gone.
Object is what the magistrate said or didn't say is not relevant to this case. And indeed, a formal hearing is a complete redo of the trial. It's not really an appeal. It's a complete redo. And this ticket speaks for itself. This is the same ticket in the file that the officer wrote at the time. It says impeding traffic.
Okay, so what he's talking about is the standard of review. Usually on an appeal, that's the first thing you have to talk about is the standard of review. So what he's saying, he didn't say it, but is de novo, which means we're just doing this as if we're doing a do-over, as if the first hearing didn't exist. So it doesn't really matter. They're not giving deference to the prior decision. She's just hearing the evidence fresh.
Improperly.
I'm going to sustain that objection. Ms. DeHart, please move on.
Okay, and this is not an appeal then? Is that what he's saying, telling me now? I was told this was an appeal.
This is your appeal from your informal hearing, ma'am. I
Right.
sustain his objection.
If I could rewind, I would, but you just watch her take the big breath before she responds to some of this stupid. It stuns her, and she's like, okay, and then she proceeds.
Regarding whatever the magistrate said, this is a brand new hearing. I don't have any information about what the magistrate said, so
Where's her picture?
you cannot question him anymore about what the magistrate said.
Oh,
I can't question him what the magistrate said? Is that what you just told me?
No, correct.
Okay.
just ask him if there's.
Oh my gosh. Okay. I guess, is the officer aware that at the intersection of Michigan and Riverview, the lane signage that's posted clearly indicates that there is a left turn lane, there is a straight through lane, and then there is a straight through and right turn lane. Is the officer aware of that?
There are, as you're coming eastbound, I'm assuming you're talking about the eastbound lanes. As you're coming eastbound, there is a left turn lane that goes north onto Austin Road. And then there are two other lanes, the inside lane.
And there it is, the turning point. Up until now, you might have felt a little sympathy, but the second it gets personal, that's when credibility starts to crumble. In court, tone matters just as much as facts. Let me ask you, if you were the judge, would this make you more or less likely to believe her?